So welcome to Unit 7, where we're going to talk about the judiciary. The judiciary is the final conversation about the three branches of government. So remember, at the federal level in this class, we're talking about Congress, the presidency, and now judiciary. The judiciary is probably the most interesting of the three branches if we look at the Constitution, because of the three branches, the Constitution says the least about this branch of government. Thus, in what unfolds in these 5 parts of the video, you'll see that there's a lot of open interpretation to how we think about the judiciary, its powers, and its responsibilities. Most people think about the Supreme Court, which we'll talk about a lot in this lecture on the judiciary, but of course, the judiciary also includes other ancillary courts under the Supreme Court. So the agenda for the video is that in the first part, we're going to talk about where the power of the courts came from. So that necessitates talking about the U.S. Constitution. In the second part of the video, we're going to talk about the structure of the courts, and this is the flavor of federalism. So we'll talk about what happens briefly at the national level versus both state and local. Third, we'll talk about the power of judicial review, which is a landmark court case, one of the very first court cases decided, Marbury versus Madison. In the fourth, we'll actually talk about the Supreme Court specifically and how it's composed of its different members. That's a real interesting conversation because it leads to other discussions about the representation of the American public in this body. And then finally, we'll talk about constitutional interpretation. Constitutional interpretation always comes up when we talk about the Supreme Court. So there are various ways to look at the Constitution and decide what it means for existing policy in the United States, because this is an ongoing issue with the court and what it does in its day-to-day work. All right, let's jump right into it and talk about the origination of the courts. So like we've done in the other branches of government, the executive and legislative, we've gone to the Constitution and looked to see what the framers said and set up for this branch of government. And when we look at the Constitution to see what the framers said, we look at specifically Article 3. This is a section of the Constitution which describes the power of the federal courts and this branch of government. With the exception of Congress, the Constitution is pretty vague about the powers of federal government. In the initial iteration of government under the Articles of Confederation, there was no court system. So the framers in this first version of government that failed didn't really put any kind of powers for a judiciary. And in practice, all litigation ended up being left up to the states themselves. But of course, 2 states would have disagreements with one another, and the power to resolve disagreements between states, and usually due to trade, was supposed to be the responsibility of Congress. But having no legal system meant that there was no national body that could solve these national legal issues except for Congress. And Congress was free to kind of litigate between the states and maybe make laws without reproach of either a federal court system or a strong executive. But of course, this also didn't take into account the fact that Congress might somehow become tyrannical or didn't do its job. So in the second iteration of American government, when we wrote the Constitution, we actually wrote in a federal judiciary. So if we look to the Constitution to see the powers that the framers decided to give this branch of government, we see that the powers are relatively broad. I'm going to quote Article 3, Section 1 of the Constitution, and this part of the Constitution says, quote, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may, from time to time, ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior, and shall at times receive for their services a compensation which shall not be diminished during their continuance in office." So, here, the Constitution is establishing a couple things in this short little paragraph. First, there's one Supreme Court. But beyond that statement, it really says nothing about the number of justices or the procedures by which this Supreme Court functions. Second, the power of Congress gives them the ability to establish inferior courts. And this says nothing about the structure of these inferior courts, how many and what they look like, or even the number of judges within those courts, but it basically says that Congress is going to control this process. Third, the exact language here is that, quote, "shall hold their offices during good behavior," which in practice has come to be understood as judges enjoy a lifetime appointment. Once they're sat on the bench at the federal level, they aren't termed out. Salaries may be increased while in office, but not decreased. And of course, this is because they want judges to kind of do their work without fear of losing money. And there is some language here about jurisdiction, and jurisdiction is the domain over which this institution has authority. So basically, what kind of cases can this Supreme Court actually hear? So there's something called original jurisdiction. This is discussed in the textbook. And the original jurisdiction of the Supreme Court is any cases dealing with ambassadors or states. So anytime we have those kinds of disagreements, the Supreme Court automatically hears those cases. Secondly, we have something called appellate jurisdiction, and anything that's appealed from the lower courts will end up here at the Supreme Court. But beyond this, and especially if you're going to read other parts of Article 3 really closely, you see that there's not that much information about the structure or even the powers of the courts. And this kind of leaves us maybe in a little bit of dilemma, especially if we were thinking about the judiciary in the 1700s. But there's this one part in this paragraph that I read, right, that said that Congress has this power to kind of deem what these inferior courts would look like. And this came in the Judiciary Act of 1789 in the first session of the U.S. legislature. So this piece of legislation, the Judiciary Act of 1789, does a couple of things. First, it specifies a number of justices on the Supreme Court. And at least initially, it established them at 6, which is strange because now there are 9. But the number of justices have fluctuated throughout American history from anywhere from 6 to 10. And the number of 9 really was settled on in the mid-1800s. Now, the number is important because you see initially we thought 6 was a good number, but it's flawed, right? We need an odd number of justices because if there's a tie, we need one justice to break that tie. Also, in the Judiciary Act of 1789, in addition to adding to the original and appellate jurisdiction, it also established what's called the writ of mandamus. And the writ of mandamus is the ability of the Supreme Court to tell the lower courts what to do. So the Judiciary Act of 1789 here is sort of saying that the U.S. Supreme Court is kind of the Supreme Court of the land. It also establishes the structure of the federal court system, which I'm going to unpack in about a couple minutes. And here, under the Supreme Court, we still have other federal courts. So most people know about the U.S. Supreme Court, but most other people don't know about the courts that exist under them in the federal level. So under the Supreme Court, we have both circuit courts and district courts. And court cases get decided here all the time in the lower courts before it gets to the Supreme Court. So there's a lot going on here in 1789 with this piece of legislation. You see that Congress does its job here and tries to give structure to the federal court system. But I'm going to move to the part 2 of the class where we actually talk about the structure of the courts. I'm going to give this conversation a little bit more meat. But to begin part 2 of the class, what I want you to think about is the Supreme Court in early America, right? So I've already established that the Constitution doesn't really say much about this branch of government, right? It was kind of unknown, the role that the court system is going to play in U.S. government. And if you look at the early Supreme Court justices, John Jay, for example, who was the first Chief Justice of the Supreme Court, John Jay left his position. He left his position of Chief Justice, which is really prestigious, to become governor. His successor, John Rutledge, never sat on the court because he takes a position in the South Carolina State Supreme Court. And their successor, Oliver Ellsworth, resigns to take a diplomatic post in France. So during the founding, being on the U.S. Supreme Court wasn't prestigious. It was actually seen to be as a difficult position. And that's because it was really difficult to travel in early America. You have this small body of justices who came from all around the country, and it was hard for them to travel to the Supreme Court, especially in light of the fact that it wasn't 100% clear the job the Supreme Court was doing in these first years of government. And the Supreme Court actually didn't meet in Washington, D.C. throughout American history, so it wasn't really settled where they would meet. At one point, they were in New York City. At another point, they were in Philadelphia. They eventually settled in D.C. And in the first 5 years of the existence of the court, they only handed down 3 decisions. Now, if you compare that to what goes on today, about 7,000 or 8,000 cases apply for the Supreme Court to hear their cases every year, and the Supreme Court decides on 75 to 100 decisions each year. So this is just a stark difference, especially in how we think about how prestigious these appointments are. And that's because the structure of the courts have changed a lot since the Constitution. Part of this is with the Judiciary Act of 1789. But other than that, let's kind of jump into how this has evolved by talking about the three levels of the court at the federal level. So we're only talking about the federal level, the national government. And we all know of the U.S. Supreme Court, and this is the highest court of the land in this branch. Here we have today 9 justices sitting on the U.S. Supreme Court. They hear cases all the time, and you can hear people talking about things called oral arguments, which is when attorneys from both sides present their positions based on the arguments. Briefs are presented to the court, and these briefs are written documents which explain the positions. Any group can write a brief to the Supreme Court. These are called amicus curiae briefs. And the justices will issue what's called an opinion, which is a written document at the end of the oral argument, which explains the outcome of the case. So the activity of the Supreme Court is really closely looked at, being the highest court in the land, and they only choose to hear the most important cases. But below that U.S. Supreme Court at the federal level, we have a Court of Appeals. Most of us haven't really heard about the Court of Appeals or what they do, but the way that this works in practice, and this has been created over time by legislation, is that we have 13 Court of Appeals across the United States today. Now, this number is not going to be important. I'm not going to ask you about this later, but it's just there's about a dozen, right? There's about a dozen in different regions of the country. There's approximately 180 judges sitting on these 13 different courts. There's around 60,000 cases that are filed in the Court of Appeals, but only 5,000 are heard. And cases don't originate here, but they're heard as an appeal from a lower court, which I'm going to talk about next, as you see on the screen, the district courts. And at this level, there's not really new evidence, there's no witnesses, there's no testimony, but judges just hear oral arguments by lawyers, which kind of explains the point of law and the decision that was made at the next level, which are the district courts. So let's talk about the district courts. This is the lowest court in the federal level. So in the Court of Appeals, we have 13 of them. In the district courts, we have 94, and they're scattered across the United States. Here we have approximately 700 judges. And each year, the district courts hear about 200,000 cases. But in reality, these cases only represent less than 1% of the total litigation in the United States. So at the federal level, there's court cases going on, certainly, but a great deal of the litigation in the United States happens at the state and local level, which we'll talk about on the next slide. But if your case is heard at the district court, your case has something to do with federal law. And if you violate any kind of federal law, whether it's Constitution or a congressional act, you're tried in the district courts first. And even in the district courts, you'll have juries or even grand juries, but sometimes in the district courts, your case will be heard by a judge. So what happens at a more local level, right? So this is just the federal national government. What about the court system at the state and the local level? This is where probably most of your personal interaction with the court comes in. Most cases in the United States are heard at the state and local courts. The federal government has jurisdiction on a couple different things, cases dealing with states and ambassadors, but even the district courts have jurisdiction on things like antitrust laws, contract disputes between people from two different states, things like interstate drug trafficking, kidnapping, and taking someone between state lines. But state and local courts have their own jurisdiction and their own system. Most often, depending on the state, right, states will have a system that looks something like the federal level, where you kind of have this lowest superior court level followed by a court of appeals, which is called the state circuit court, and a state supreme court. So in California, we have a California state supreme court, which is separate from our U.S. Supreme Court. So states will employ their own system, which is kind of modeled off the federal level. And local level will have municipal courts. And municipal courts, there can really be a great deal to these courts, especially because most of these courts are dealing with something local laws, and maybe it's something as simple as traffic violations. But even if your case starts at the local level at a municipal court, it can be appealed up and up and up. So if you don't like the decision at the local level in your municipal court, you can eventually appeal it up to the state level. And if you don't like the decision up at the state level, you can appeal it through those levels all the way up to the federal level. And once you end up at the federal district court, you can appeal that all the way from the district court to the Circuit Court of Appeals to the U.S. Supreme Court. So you always have the decision to appeal a case once it's been decided, and it'll theoretically move up the ladder as you move from there. So the structure of the court system is born out of just practice and legislation. We've kind of determined this is how the court system works. And you see in the way that I'm describing it here, a lot of this is kind of predicated on federalism and how we discuss federalism in Unit 2 of the class, but it's extremely complex. And that's simply because there's 300 million people and thousands and thousands of cases heard each year. So I'm going to move on to the third part of the video. We're going to talk about the power of judicial review. And one thing that I want you to consider, that because judicial power isn't really well defined in the Constitution, we kind of need to take a step back and go back to a legal theory by which the courts have kind of derived their power. It's not immediately clear, right, that the judiciary has any kind of power, because in the Constitution it doesn't really say what the judiciary is responsible to do. And although we have created all this legislation that kind of establishes the structure of the courts, this legislation really isn't giving the court teeth. So the teeth, or the power, or the ability for the court to actually do its job comes in something called judicial review. So whenever you hear the power of judicial review, it just really means the power to adjudicate or even just review court cases. So court cases are just disputes between citizens, maybe between entities that are greater than citizens, groups, states, maybe even countries. But in the government, it's really the responsibility of the court system to adjudicate these disagreements, these court cases. And it's not immediately clear in the Constitution that it would be the judiciary who is responsible for doing this, right? Because it could be Congress, it could be the president, it could be some other regulatory body that we've never created. But the power of judicial review is given to the judiciary in this Supreme Court case, Marbury versus Madison. This is one of the earliest cases of the Supreme Court. And this judicial review story is relatively complicated, but it's really, really important. You'll see that this is really about the tension of the branches. It's about the tension of people or parties when they transition from power. And it's a Supreme Court case ultimately. So the Supreme Court case basically hears a case that gives it its teeth, that gives it its power. So let's jump into this by talking a little bit about this background. This begins with John Adams. John Adams as the second president of the United States. And when John Adams runs for re-election in his second term, he's up against Thomas Jefferson, who ends up becoming the third president of the United States. John Adams was a Federalist, and Thomas Jefferson is the first of what's called the Democratic Republicans. Adams believed as a Federalist in strong national government, and Jefferson, as part of this new Democratic Republican Party, so it's both, was in favor of stronger state governments. Adams loses to Jefferson, and for the first time in American history, in this third presidency of Thomas Jefferson, the Federalists, those who argued for stronger state government, lost not only the presidency, but they also lost Congress. So at this moment, the Federalists in Congress realize, okay, they're going to lose their majority, and they pass a last-minute law. And this last-minute law is the Midnight Judges Act of 1801. And this piece of legislation basically adds a large number of justices to the federal court system. So it's increasing the size, which Congress can do. And by increasing its size, it means that John Adams will have to make a bunch of appointments before he's vacated the office. And Adams ended up appointing judges who sympathize with the Federalists and stronger national government. And the courts would be stacked in favor of Federalists as a result of this. And this is arguably within the bounds of the Constitution. The Constitution does provide for both Congress and Adams to do this. Now, in response, the Senate waited until the very last minute to confirm these appointments, and they did, but in order to confirm the appointments and for it to take effect, the Secretary of State at the time had to deliver what were called commission papers. So they had to actually hand this paper to the appointees. And the Secretary of State at the time, John Marshall, was appointed Chief Justice, and John Marshall, in this transition himself, basically assumed that these commission papers, these appointments, would still hold up, even though the papers were never hand-delivered. So when Jefferson takes office, there's a problem. Jefferson instructs his new Secretary of State, James Madison, not to deliver the commission papers to the remaining appointees that John Adams had made. So the appointed justices, these last Federalists, couldn't be sworn in. And William Marbury, who's the petitioner in this case, was one of those justices. He was supposed to be seated on behalf of John Adams and the Federalists in the Washington, D.C. Circuit Court. And he brought his case to the Supreme Court when the Secretary of State, James Madison, wouldn't seat him. So Marbury versus Madison is these different politicians from factions. Marbury is a Federalist who wants to be on the court. Madison is Secretary of State, who's part of the Democratic Republican Jeffersonians, and they disagree about whether or not Marbury should actually get his appointment. Should he be seated in the Washington, D.C. Circuit Court, federal level? And basically, Marbury was asking whether or not the Supreme Court could actually hear this case. Could the Supreme Court order the D.C. Circuit Courts to grant Marbury his appointment? And the decision that's made in this case is that the Supreme Court basically says that Marbury is correct in asking for the Supreme Court to do something. And the Supreme Court in response says that the power of the court is ultimately to determine when two laws conflict with one another. And this is a clear instance when the Constitution and the Midnight Judges Act conflict. But could the Supreme Court actually force the D.C. Circuit Courts to issue Marbury's appointment? The Supreme Court says no, they cannot. They're not going to seat Marbury. And the reason why is because the Constitution only gives the Supreme Court jurisdiction over two kinds of cases. Remember I said this: original jurisdiction and appellate jurisdiction. So the original jurisdiction is about ambassadors and states, and appellate jurisdiction is when the case starts in lower courts and kind of rises up 3 levels. The Supreme Court says that no, they can't do this because it's not part of its jurisdiction. Thus, the appointment is denied. They're not allowed to basically give Marbury his appointment, although Marbury was correct in bringing this case to the Supreme Court. Now, this sounds kind of counterintuitive, right? Because the Supreme Court is kind of reserving its power here. It's not giving Marbury his appointment, and that might be misleading because it's giving you the sense that it's limiting the power of John Adams, right, to seat his justice. However, this gives the court officially, for the first time in American history, the power of judicial review. It allows them to be the arbiters. It sets up the Supreme Court as the body which mediates a disagreement between branches of government, or as the body that mediates disagreements in a transition of power. And this makes the Supreme Court extremely powerful. Keep in mind the judiciary does have its limits. I mean, the president selects who sits on the court. The Senate approves that appointment. However, in the Constitution, there's not much written about the judiciary, so there's not as many checks and balances against the judiciary. But here's the Supreme Court saying in Marbury versus Madison, this is our job, and this is no one else's job. And in effect, and we know this as history has gone on, once a case is really decided in the U.S. Supreme Court, it's really hard to overturn that decision. So the decision can only be overturned in 2 ways. One, the Supreme Court hears a similar case and overturns its own decision, which doesn't happen very often. And if it does, it happens when the entire court's membership has changed over successive generations. And the second way that a Supreme Court decision is overturned is if we pass a constitutional amendment. And that's extremely hard to do. We've only passed 27 amendments in the entire history of the country, whereas there's been over 10,000 proposed. So Supreme Court decisions are remarkably powerful. They've given themselves this power in Marbury versus Madison. So it's not only about this legislation that Congress is passing for the structure of the courts, it's really about this idea and precedence that the court sets for itself, saying that, yes, we have this power to be the adjudicators, to be the mediators, to be the decision makers in federal government. So now that we've talked about judicial power, I kind of want to move on to just focusing on the U.S. Supreme Court in part 4 of the video. And it's important to have a conversation about the Supreme Court because as the highest court of the land, we need to know what's going on and who's on this court. So there are 9 justices currently sitting on the bench. We've been at 9 since the mid-1800s, and I'm not going to ask you to remember these names, but you've probably heard some of them in news or media, or some of them have been appointed recently by President Donald Trump. So we have justices, number 1, Samuel Alito, number 2, Neil Gorsuch, 3, Brett Kavanaugh, 4, Clarence Thomas. And these 4 justices represent the conservative wing. Our swing vote justice, who's in the middle of the court ideologically, is the Chief Justice, John Roberts. Now, the Chief Justice is kind of like the administrative agenda setter of the court. They're responsible for kind of moving the court along in each of its terms. Now, I'm saying that John Roberts is kind of the ideological middle, this 5th justice, yet he's pretty conservative. The court is leaning conservative more and more as time has gone on. Because Republican presidents have been more successful at appointing justices during their administrations. So let's talk about the 4 remaining justices who are the liberals of the court. And we have Ruth Bader Ginsburg, Stephen Breyer, Sona Sotomayor, and Elena Kagan. So I think it's important to kind of distinguish amongst these 9 justices. Some are conservative and some are liberal. Now, some folks are purists and like to say, well, the Supreme Court shouldn't really look partisan. And indeed, I think most justices or even lawyers would probably give you that same idea or perspective. Yet in practice, especially as the country has become more polarized, ideologically separate, it is the case that these justices vote on ideological lines on cases as we move forward through American history. So part of discussing the composition, even the ideology, is like, well, how do they get there, right? How are they nominated? So let's talk about the nomination process a little bit. Presidents are responsible for nominating the justices to sit on the bench, yet the Senate is responsible to actually confirm their appointment. This is called the advice and consent power. The Senate's official role in this process is confirming them, but also to give the president advice and consent him, or give their consent on the president's nominations. And the president basically will have the sole discretion as to put up whoever he wants as a nominee to the Supreme Court. The Senate then holds hearings, basically vets those candidates, and has to agree by majority of vote whether or not to seat that person. Typically, when we look at Supreme Court nominations, their legal career is important. Every single justice in all of American history has had some sort of legal career. Every single justice has been a lawyer, a JD, and 2/3 of our justices approximately have been judges on lower courts. Typically speaking, presidents who are Democrats will appoint liberal justices, and presidents who are Republicans will appoint conservative justices. Now, it's not always the case that this happens. Sometimes presidents erroneously appoint someone that they think will be, for example, more conservative, but then they end up voting more liberal over the course of their term. Typically, we won't really know much. That's what the Senate hearings are supposed to kind of vet and flesh out. They ask these nominees lots of questions, and some of the questions can kind of center around how they would vote on potential cases. Other than the legal aspect and the partisanship aspect, presidents make other kinds of considerations. Sometimes in recent history, presidents will appoint specific justices because of things like race or gender. So Sonia Sotomayor, who was nominated relatively recently by President Obama, and she was hailed as a really fantastic choice for the court because she was the first Hispanic woman to ever serve on the court in its history. Other than that, some other groups will weigh in during this process, during the nomination and consent process. The Department of Justice will issue briefs on nominees, other lawyers, interest groups. The FBI does its background check on each nominee that's put up. The American Bar Association publishes a public opinion about each of the nominees. And of approximately 115 justices that have been put up, only 30 have really failed. Talking about failures, it's good to point out that sometimes these justices are rejected by the Senate. One of the most memorable recent nominations that failed in modern history was that of someone named Robert Bork. Robert Bork was nominated to the Supreme Court, but lost the confirmation vote in the Senate 42-58. Robert Bork was nominated by Ronald Reagan, and Bork was loved by the Republicans in the Senate because he was a champion of conservative causes. Liberals, on the other hand, Democrats in the Senate, believed that Bork was going to be rolling back constitutional rights as soon as he got on the bench. Thus, what began in this set of hearings for Bork in the 1980s was a really partisan set of hearings. And Bork is instrumental because in subsequent nominations, presidents have kind of been reluctant to put up someone who would be perceived as being too ideological, in essence because they were afraid that they would get, quote, borked. And it's kind of been this term that other presidents have picked up on. It's very much the case that a lot of these hearings do become more ideological, where senators from different sides of the aisle take a really fervent stance for or against the nominee, just simply based on what the perceived differences in political party. There's other reasons why justices are sometimes rejected. Douglas Ginsburg, who was Bork's replacement, was rejected because during the hearings we found out that Ginsburg liked to smoke marijuana on the quad at Harvard with his students. So that wasn't a really good PR piece for Ginsburg, and his nomination was rescinded. Harriet Miers was nominated under George W. Bush. Harriet Miers got her nomination rescinded because there wasn't a ton of information about her. She had never sat on the bench, and she was White House legal counsel and a close Bush family friend. So a lot of Republican justices actually spoke out against Harriet Miers' nomination, and President George W. Bush rescinded that. So they do happen, these failures. Next, I want to talk about the demographics of the court. And here, the conversation is, in all of American history, it's really clear that justices represent the elites. They're nominated, they're selected from those who have privilege in society, and there's not a lot of diversity amongst of the people who have sat on the court. Now, keep in mind, in the Constitution or even legislation, there's really no requirements whatsoever to be made a justice of the Supreme Court. If a justice were to pass away, Donald Trump could arguably nominate me to be Supreme Court justice because there's nothing that says that I couldn't be the nominee. And there's no qualifications. I don't need to be a lawyer. I don't need to be a sitting judge on a court. So it's really up in the air. But in practice, in terms of things like gender, age, race, religion, job, education, so on and so forth, presidents have really selected a specific segment of the public, so to speak. So let's talk about gender. In all of American history, we've only had 4 female justices, and currently 3 women sit on the court. In terms of age, the justices on average are 66 years old. Currently, the youngest justice sitting on the bench is Neil Gorsuch, who was appointed by President Trump, who's 51, and the oldest justice is Ruth Bader Ginsburg, who is 86. In terms of race ethnicity, in all of American history, we've only had 3 justices who were not white, and one is Sonia Sotomayor, who's Latina, and then we had Thurgood Marshall and Clarence Thomas, who were both African American. Religion, predominantly Christian, mostly Protestant. There are about a dozen Catholics who have sat on the court's bench, a few Jewish people, but mostly it tends to be the fact that our justices are Protestant. Every single justice has been a lawyer. 2/3 of them have sat on a lower court before the Supreme Court. Alina Kagan is a really good example of someone who's never been a judge, but she was Solicitor General, who is kind of the president's liaison to the court system under President Obama. And I think one of the most illustrative ideas about these judges being part of the elite and privileges when we talk about their education. Most of these judges come from elite schools. Harvard and Yale by far have the highest number of former students become Supreme Court justices. In the current court, these justices have gone to Harvard and Yale. Ruth Bader Ginsburg is the only one, I believe, who comes from another school, which is Columbia Law. In terms of undergraduate work, though, it does runs the gamut. It's not just Harvard, Yale. It's Harvard, Stanford, Princeton, Georgetown, Cornell, right? So, I mean, it's still these really elite institutions, right? So it ends up being the case that you really have to be a part of a specific segment of society to be in the running to be a nominee for the Supreme Court. And on a final note, I would say that if we look at the income levels, which we kind of know about, of the current sitting justices, on average, the net worth of these justices is $2 million. Ruth Bader Ginsburg is the justice who has the highest net worth, and she's reportedly worth around $20 to $40 million. Given how powerful the courts are in deciding or adjudicating between disputes in federal government, it should be alarming that these justices do not really adequately represent the American public. Now, this is somewhat shifting over time as we become more aware of these issues and more aware of these demographic shifts in the American landscape. But nonetheless, you should be fairly critical, especially if we kind of take a more critical view of American government overall, thinking about how elites have so much control of government. And I've stated previously, the judiciary is the branch which has the fewest checks against us or against itself. So in that case, it really is kind of disheartening to see that on factors like religion, income, race, age, gender, that the justices are remarkably unrepresentative. So I'm going to wrap up part 5, or this unit of the class, by discussing constitutional interpretation. We've kind of laid out different elements of the judiciary, the structure, the power, the composition, and now we're kind of in a position to kind of think more holistically over the course of American government. How has the Supreme Court, with this immense power, gone to interpret the Constitution? So this is the highest court of the land, the Supreme Court, and by majority vote, they decide on 70 to 80 cases per year. They hear oral arguments, get opinions from all sorts of places in amicus curiae briefs, and they issue opinions, right? But how does the Supreme Court make its choices about these opinions? Now, one way to think of these decisions is that the court doesn't really have active power. They're not really creating their own need to action. They're not moving legislation, so to speak. They only react. They only decide on cases whenever the issue is brought up to them. A defendant shows standing to the court, which means that they just have to show that they have a substantial stake in a question about government. And the court has a significant amount of discretion about deciding which cases they want to hear to begin with. And I kind of brought this up, at least implicitly, throughout the course of this video, and talking about the Supreme Court is first ideological, right? That there's disagreements on the liberal and conservative perspectives between these justices, but also, which I think is a more important second question, and that's one about the Constitution, right? The justices are now in a position, because of judicial review and because of the structure of the system, because of who the justices are, they're in a position to evaluate where power and how power is derived from the Constitution. So this includes like powers between the branches, powers between the different levels, federal, state, local. This includes power over liberties and rights. So the Supreme Court is adjudicating a lot of questions about who really has the ability to do things in government. These are huge, big questions. And in practice, what has kind of evolved is the court's ability to decide constitutional questions on a judicial philosophy. And this judicial philosophy has two names. I'm going to talk about them separately. First, I'm going to talk about judicial restraint as a philosophy interpreting the Constitution. And second, I'm going to talk about judicial activism. So when I talk about this as judicial philosophies, what I want you to think about is that as a justice sitting on the Supreme Court, you have a specific perspective about how we should read into the power of the Constitution. It can be one of restraint or one of activism. Now, I think as time has gone on, part of this has become an ideological conversation as well, like I was saying in the beginning parts of the video. But nonetheless, it's a really interesting conversation about how we should treat the Constitution in terms of who really has power in government. One last thing before I jump into each of these philosophies on their own, the court really doesn't have the power to enforce anything. We talk about the court as being really powerful, as kind of asserting its dominance with the other branches, but also with the different levels of government, state and local. However, this has been customary. This is a custom and tradition that we've developed that's not really anything beyond a norm or tradition in American society. The Supreme Court is something that we've all kind of just implicitly agreed to listen to. It could definitely be the case that one day we have an institution, maybe the president or Congress, come along and say, well, what is the Supreme Court really doing, right? Like, they don't really have any official power. So regardless of these judicial philosophies and how we read into the Constitution, just always keep that in the back of your mind when we're thinking about a constitutional power of the Supreme Court, is that in reality, there's no body that enforces the decisions that the Supreme Court makes. Let's jump into judicial restraint. So when we talk about judicial restraint, this is when a justice has a particular perspective about the text of the Constitution. And the justices who are practicing judicial restraint think if the intention of the Constitution in reading the text is unclear, then they have to defer to Congress in that case. And these justices really believe that the court shouldn't make law. You shouldn't legislate from the bench. Another word for these justices who practice judicial restraint are those who are called strict constructionists. This justice who passed away relatively recently, Anton Scalia, was known as a strict constructionalist. Scalia was a really strong proponent of judicial restraint, and he gave a bunch of lectures on this. And he was a really strong advocate in the sense that he really believed in this philosophy, but also did a pretty good job in persuading others to believe in it with him. So he said things like, quote, "What I look for in the Constitution is precisely what I look for in a statute, the original meaning of the text," end quote. So Scalia's main argument here is that the Constitution really hasn't changed, right? It's the same text, and society has been trying to mold itself to interpret what the document means. But, quote, "The whole purpose of the Constitution is to prevent change, to embed certain rights in a manner that future generations cannot take them away," end quote. So Scalia is kind of thinking about the perspective of the framers in this sense when they wrote this text. I mean, the text is what it is. However, the text was written to protect our rights. And if we haphazardly interpret the Constitution as time goes by, we're not abiding by what the framers have set forth. And we've agreed in this American government to abide by this one single document, and doing otherwise will kind of speak ill of what the framers intended. Next, let's jump into judicial activism. So judicial activism is the second philosophy, and justices who practice judicial activism believe the Constitution is evolving as a document, that the intent of the framers is really hard. It's really difficult to ascertain because it was just a different time, right? 1789, the justices didn't even want to sit on the court because it was so hard to travel across America. There is no television, there is no radio. Everybody that holds power are property-owning white men. And even then, the founders were not really in total agreement about American government when they were writing this Constitution. So if we're placing a lot of meaning in the text, the context is important, right? And there's also no one alive from that time to answer questions about what they really meant anyway. So the interpretation of the Constitution, for those who practice judicial activism, is that the Constitution should really change with the times. It should evolve. And they typically call the Constitution a living document. Current Justice Stephen Breyer is a judicial activist. Same as Scalia, Breyer gives some pretty excellent talks about what it is to be a judicial activist. And Breyer said things like he would like to interpret the Constitution because it was helping the country run more efficiently. Quote, "It increased recognition of the Constitution's general democratic participatory objects, and it can help the courts deal more effectively," end quote. And somebody like Breyer would say the document wasn't really made to solve current issues, contemporary problems, yet the court was responsible for solving complex issues of the time through things like discussion, conversation, investigation. And the Constitution is meant to be translated in this current time through these experts who are kind of going through these discussions and investigations. Quote, "The Constitution does not resolve and was not intended to resolve a society's problems. Rather, the Constitution provides a framework for the creation of democratically determined solutions," end quote. So it's kind of like a framework, a guideline. Breyer isn't really saying that the Constitution shouldn't be listened to, but rather it should be a guiding force in how we interpret contemporary issues. One of the mistakes that people make is they talk about judicial restraint as being a conservative philosophy and judicial activism as being a liberal philosophy. Well, it is the case that Anton Scalia, judicial restraint justice, was a conservative, and Breyer is a liberal who believes in judicial activism. I wouldn't think of these as being either liberal or conservative, because you can see judicial activism on behalf of both parties. For example, the landmark decision legalizing abortion in the United States, Roe versus Wade, that's a good example of liberal activism, right? There's not anything in the Constitution that gives us a distinct right to have an abortion, yet these justices interpret it from the Constitution. So that's judicial activism from the liberal side. On the other hand, we have court cases like Citizens United versus FEC, which we haven't talked about yet at all, but we'll talk about this as we move through the rest of the class. This is the decision that allows corporations, interest groups to donate unlimited amounts of money to elections. It's been remarkably effective in changing the American political landscape, and that is a conservative idea. This is a conservative example of judicial activism, but there is nothing in the Constitution that gives corporations or interest groups this right. Now, I will concede that there's much more activism centered around liberals than conservatives. Liberals tend to prefer activism for sure, but there's definitely examples of judicial activism from both parties. And I think the final place to end this unit and to end this video is to really ask yourself the question about which is better, right? And there's no clear answer because you can make a really good argument for judicial restraint and judicial activism. For those who believe in judicial restraint, there's something to be said about thinking that justices should be more reserved in how they think about their power, right? The judiciary is not on equal footing with the other two branches of government, and it's not representative of society. So in that sense, because they're so powerful, because they're not closely connected with the public, you should probably think that justices should restrain themselves, right? That the government shouldn't have the overwhelming power that an activist court would ever dream of having. Now, if you're in favor of activism, you think probably that the government needs to respond to problems quickly. And sometimes the government can be taken to brand new avenues that it never anticipated. So it's kind of a necessity based on what's going on, and sometimes really serious problems, that justices need to be more in favor of activism in order to deal with the problems that our country faces. It's an interesting conversation, again, because I don't think there's a clear answer. But this tension between judges who are more in favor of judicial restraint versus judicial activism is kind of the center, I think, mostly of how the justices think of their job in terms of deciding court cases. So what I would really want you to walk away with that at the end of this unit is this idea that, yes, ideology is becoming more polarized. We talk a lot about Democrats, we talk a lot about conservatives, but there is an idea in the court system, at least, that impartiality reigns true, that these justices theoretically do not think of themselves as liberals or conservatives, but rather this judicial philosophy of that being restraint or activism is kind of a guiding force in how justices think about the decisions that they make.